Good morning, everyone. Welcome to Cornell Cooperative Extension for our monthly Consumer Issues program. I'm Mike Danaher. I'm an Assistant Attorney General in the Office of Acting Attorney General Barbara Underwood. And it's a pleasure to be out here today to speak with you about one of the topics that we hear a lot about in the Attorney General's office, and that is issues related to the landlord-tenant relationship. We like to talk to it the rights and responsibilities of landlords and tenants. I like to keep it neutral so that it's not, favoring landlords or favoring tenants or anything. It's intended to be an informational session about what this whole relationship is, how does it go about, how do we sever it, and hopefully the information that we can talk about will help both the tenants and the landlords to avoid problems in the first place, and then to help them resolve problems that may occur as they come out. So I always like to start to talk about this topic, which we do. This is one of the rare ones we do twice a year here at Cornell Cooperative Extension. And to talk about what is this whole deal? What's this? How does this relationship is it created? What does it mean? How is it recognized by law? And the question comes down to is, what is a lease? And a lease is merely a contract between a party who wants to give up something, which is the landlord gives up exclusive use and occupancy of and we're talking about residential leases. We're not going to talk about commercial leases. A residential structure to someone who wants that, which is the tenant, again, exclusive use and occupancy, in consideration of a payment of money, which is the rent. In order to make it a contract, there are certain things that must be present in order for there to be a contract. And there needs to be an offer. You go to law school, I spent a whole year on this. There's an offer, there's an acceptance, and there's consideration. So somebody makes an offer, somebody accepts that offer, and it can be somewhat of a gray area of who's the one that's actually making the offer, but there is an offer and someone ultimately accepts it. And there is consideration passing, meaning somebody is either giving up something that they're undertaking an obligation that they didn't otherwise have. So in the whole context of why this is a contract is, there's an offer, using the example, I'll rent this place to you for $850 a month. With the other side saying, I accept, I will rent this place from you for $850. So we have an offer and an acceptance. It could be the other way around. I offer to rent your place for $850. I accept that you'll do that. So the offer and acceptance. The consideration. Consideration can be a promise. So the landlord is promising to give up his or hers exclusive use and occupancy of the structure that they own. On the other hand, the promise from the tenant is, I agree to pay you $850 a month for a year. Offer, acceptance, consideration, contract. Parties agree. So, that being said, you can have a lease agreement, a contract, up to a year without having anything in writing. You can actually have an oral agreement. Now that I said that, forget that. The best advice that I can give to landlords and tenants is get it in writing. Put everything down in writing. Put everything possible associated with this lease agreement in writing. And that's to benefit the landlord, and it's to benefit the tenant. Put everything in there. How much is the rent? What is being rented? Is there anything else included? Is the garage included? Put it in there. Who's responsible for the water? Who's responsible for cleaning the sidewalks? Can you have pets? All these things, as anything you can think of, should go in there. Now, tenants, you're presented sometimes with a pre-form written document. It says, here's the terms. Could be a few pages, could be 10 pages, whatever. And there's something in there that you don't like. And first of all, don't agree to it if you don't like it. I can take care of that later. No, take care of it now. Or there's something that you want added. Just because it's a pre-printed form doesn't mean that you can't write on it. If there's something that is changed, you cross it out and put in the change. You can put in your initials. Both parties can put in their initials just to verify that that is what the agreement is. The more things that you put in there, the more contingencies that you cover, the better for both parties. Because everybody knows what the deal is. Now, there are some, well, just to tell you about the laws themselves. The law on landlord-tenant and the relationship is all over the place. It would be nice for me to be able to tell you, hey, just go to this book, and it has all the laws in New York. Although, we do have a booklet, the Tenants' Rights Guide, that has a lot of good information in it. Some of the information is not pertinent to us here because there are special rules in New York City that don't necessarily apply here in upstate New York that are in that booklet. But that's a good start. And it's pretty general, and it explains a lot of the things that we'll talk about here. But that's what we're giving you the information of what the law is and where it is. And when you see in our booklet, you'll see that there's all different types of laws that are out there. And so it isn't like you can go to the library and pull down this one book. You know, obviously, with me being a lawyer, we have this law library in our office. And of course, now everything is online too, so we can just get the law from our computer. But we have one wall of books that are the laws of the state of New York. And there's probably, let me make a guess, 150 volumes of all the different laws. It's lots of books. Well, it isn't just one, oh, landlord-tenant law, let's take it off. That's not how it works. Actually, the law in New York is contained in many different places. We have a real property law. That seems to make sense, real property law. We have a general obligations law. We have a multiple dwelling law. We have a law called, we affectionately refer to as the RPAPL, which is the Real Property Actions and Proceedings Law. That a lot deals with the proceedings associated with evictions. So it's kind of all over the place. You have to grab a bunch of books out of there. But what we're here to talk about today is what all those books mean to landlords and tenants. The way I like to look at it is, what are the rights and obligations of tenants, and what are the rights and obligations of landlords? And then when we talk about that, then we can see what everybody has the responsibility to do. Let's first start with the obligations of the landlord, which kind of mesh with the rights of the tenant. But the first and foremost obligation that I like to mention as far as the landlord goes is the landlord must provide a habitable residence. There is implied in every lease, the law implies, in other words, puts in, regardless of what the document says, the law puts in an obligation, a warranty of habitability, which means that the residence is livable, safe, and sanitary. That's really basic. It doesn't mean the tenant gets the Taj Mahal. It doesn't mean the tenant's entitled to have their walls painted. It doesn't mean that the tenant's entitled to have new carpets put in. It means that it is livable. Basic, livable. What do we think of when we think of just basic living? Heat, in the winter, of course. Hot water, free of vermin, and otherwise livable. The house, there is a structure. that can be lived in. I like to think a good, not a definitive rule, but a good rule of thumb is code. Does it meet code requirements? Just kind of a minimum level. It's got to be safe, sanitary. So that's kind of it as far as that obligation goes. And what happens in the situation where the tenant doesn't get something that's habitable? First of all, not impossible, but difficult to argue that the apartment is not habitable when the tenant continues to live there. I know there can be difficult situations about trying to get out and things like that. But if there's gas leaks, if there's rodents, or it's unsafe to live there, that's a pretty good line of habitability if it's unsafe to reside there. What does the tenant do? Well, there are certain things that the tenant can do. Some are better options than others. I understand that. But regardless of whether it's a good option or a bad option, it's still an option. One, first and foremost, is the tenant, again, uninhabitable. The tenant has the right to vacate the apartment, and frankly, should in a lot of instances. Another theory in contract law is that when one party to a contract breaches it, breaks it, doesn't fulfill their obligations, it removes the obligation on the other party's behalf to fulfill their obligations. Therefore, if this apartment is uninhabitable, the tenant can leave because the landlord breached, because we say this warranty attaches to every lease. So they breached the contract by the breach of warranty of habitability. The tenant can move out with no further obligation under the contract on their part, which is they can move out and they're not obligated to pay rent any longer. That's one of the options. Another option potentially is for a reduction in the rent, to have some portion of the number we were using earlier, $850, they can potentially have that reduced because they are not able to reside in it. Now that gets into really a gray area, simply because with a reduction in rent, you're usually talking about not total uninhabitability. You might not have access to something that you had bargained for. That's more a breach of the contract itself. In those circumstances, in every circumstance, there should be a discussion with the landlord from a tenant's perspective, or from the landlord should speak to the tenant if there's any issue. Communication is number one. That's a given. Let's just say that that's a given part. Try to work it out. If not, the tenant could potentially go and sue the landlord for a reduction of the rent because they did not get what by the terms of the agreement the parties agreed to. In an emergency, I can emphasize that, emergency, what the tenant can do, first of all, must try and contact the landlord first. But in an emergency, the tenant could, if they couldn't get the landlord to fix things, or the landlord hasn't been expeditious in getting those repairs done, can go out and have somebody do the work for them to make it habitable, to get them over that hump, and then charge the landlord back for that. How's that typically done? What's done is, let's use an example of there's no water. Got to have water. And you contact the landlord, and says, I'll get to it next month. Well, you can't wait. Well, first of all, it's a breach. If you want to get out of the lease, that's one. But you don't want to move, and it's got to get taken care of. If the landlord does not do it, I try to contact him a few times, document everything. Doesn't get done, the tenant could contact the plumber, and the plumber comes out and the plumber looks at it and says, that's, yeah, there's a problem. You got a leak or you got something going on and this has to be fixed or that has to be fixed, and fixes it for $600. So then what happens is that the tenant could deduct it from the rent. So then there'd be $250 plus a copy of the bill that makes up the $850. Now the landlord could come back. He could be saying, well, you know, you didn't pay me the full $850. You said, well, I did. Well, I'm going to sue you to evict you. Fine, go ahead. And you go to court and you show to the court, I contacted him 5 times over 4 days. He said he'd get to it, didn't get to it. I call him. He said, I forgot about it. And then they called him again. I forgot about it. Oh, I haven't gotten around to it yet, kind of thing. I did it. I took care of it because I needed water. What I don't recommend the tenants to do, I don't recommend holding the rent hostage. I am not paying you until you do this, that, or the other thing. You're buying yourself an eviction proceeding in that event. You could do it. Here's the problem that runs into it is that you have, let's say it is the $600 and you owe $850 and you don't pay the $850. Well, you're withholding rent because you owe them $250, the $600 to do the fixing plus the $250. So you just hold, and you hold the rent $850 for 3 months, saying that it's still not fixed yet. Well, you could have had it fixed within that period of time. And you can't correlate the withholding of the rent other than saying, I'm just not doing anything. It's usually better off when you can go, so then you get sued for an eviction, and you go for failure to pay rent. They try to evict you. And you can say, well, you know, I've had this water issue, and it's been 3 months. Have you had it checked? Yes, I had it checked. How much is it going to cost to fix? $600. We haven't paid $850 for 3 months. You run the risk of the court finding that you did not pay rent that was due. It's a risk. I would say the best bet is to get past that risk. If it's $600 to fix, and you gave proper notice, keep proper records, you pay the $600 of the $2, and then you give the difference $250. The landlord is going to be much hard pressed to try and evict you when he knows going into court you're going to walk in and say, Judge, this is a case for failure to pay rent. I paid the rent. And the landlord's going to say, no, you only paid $250. Say, Judge, he admits I paid $250. Here's a copy of the bill from the plumber for $600. I paid that because I notified the landlord on this date, this date, this date, this date, and this date. I didn't have water. It didn't get taken care of. I took care of it, and I paid the bill. That was his responsibility. So I paid $600 for the plumber, $250 for the rest of the rent. I paid him $850. Judge is going to look at him and go, why are you here? You didn't take care of the water. They took care of it, and the rent's all paid. I find that to be much more satisfactory response. But, you know, if you do hold it back, your defense is going to be that things weren't done, and it's not my responsibility to fix the water. So, in the emergency, repair can be made and deducted from the rent. Obviously, contact the landlord first. Another way to document the habitability issue is to call code to come and inspect to show that they don't have water. It helps for a couple of reasons. One, rather than you going to court and suing the landlord to get a reduction in your rent or whatever, code enforcement, I know in Ithaca they have a pretty active code enforcement office, that if there isn't any water, they're going to be contacting the landlord to say, you got to get your butt out here and get this water on. And they can cite them because it's a violation of the code, and they can be penalized for it as well. So there's some incentive there. What happens in the situation where it might be a multiple unit building and there's noisy tenants, noisy other tenants? The way I look at that is you treat it no different than if you owned a house and the neighbors next door owned the house. How would you normally handle that situation? You'd call the police for the disturbances in the neighborhood. You know, they're playing rock and roll at 3 o'clock in the morning when you have to get up to work the next day. Similar in this circumstance. The landlord is not responsible for the behavior of other tenants. Although, give them notice, give the landlord notice, because my experience has been with a good landlord, they would just as soon get rid of one noisy tenant than lose the 3 other tenants who are going to move out because they can't stand living in the place with all the noise. So that the good landlords are going to take care of that thing. Some have argued that if the landlord does not take care of that problem, it could be a breach of the warranty of habitability. There have been no tests on that I've been aware of. So I would say you handle it the way that you would normally otherwise handle the next door neighbor or something that's noisy. Try and discuss it with them, notify the landlord, and also you can contact the police. So that is the landlord's obligation as far as the structure goes. But there's another aspect as well, and that is this aspect dealing with security deposits. What is this whole security deposit? If I asked many of you, if I said to you, what is the law on how much a landlord can take as a security deposit, I'm sure that there are some of you, maybe not in this room, but out in TV land, who would say it's 1 month's rent. Security deposit is 1 month's rent. That's because that's the way it's been so much that we somehow think that that must be a provision. There is no law on how much a security deposit can be. It can be 6 months. It could be 2 months. There doesn't have to be a security deposit. There is nothing said about how much it is. The only thing that is said is how it's handled, the way that it is handled. If I gave you one fundamental principle in law, you could answer almost any question that I ask you on how they handle the security deposit. And that fundamental question is, whose money is the security deposit? Anybody know the answer? Whose money is the security deposit?
Theirs, the tenants.
The tenant's money. The tenant's money, and that is correct. So, that being known, even though you've handed the money over to the landlord, the money still belongs to the tenant. We can ask any question related to how it's to be handled, and you can answer most of it, such as, can the landlord take the money and put it in her checking account? No, because it's not her money. It's the tenant's money. It must be kept separate from their landlord's own money. And there's a philosophy behind that law, a very valid philosophy, and that is when a landlord puts the money in her account, psychologically it takes on a new existence as my money. And it's much harder to pry out my money. At the end, I have to give my money back to the tenant. The law says avoid that whole psychological problem. If you keep it separate and it's never your money, it's so much easier to give it back at the end. So it is not the landlord's money. It is not additional rent. It always remains the property of the tenant and can't be commingled. There are some other add-ons to it. Although it cannot be commingled, if it's a 6-unit building or more, the law has special rules, and that is it must be placed in a New York State venued entity. So an entity that has a presence in New York. It must be placed in the financial institution in a interest-bearing account. Now, this is more a theoretical argument because we're in 2018. When I first started doing this back in 1998, 20 years ago, stories were a little bit different back then. The economic situation was a little bit different back then. And interest rates on savings accounts were much higher than they are nowadays, even if you can get interest. But it had to be put in an interest-bearing, it has to be put in an interest-bearing account. And so then you say, okay, if it's in an interest-bearing account, who gets the interest? The tenant, because it's the tenant's money. So there's one proviso that has made this argument now theoretical, and that is the landlord can keep a 1% administrative charge for handling the escrow account. And with the interest rates being so low on bank accounts, that probably gobbles it all up. But I know a lot of tenants that say, I'm not going to bother with that. Or a lot of landlords, I'll give the tenant whatever interest is in there. Now, how does it get handled? The landlord does not have to have a separate account for every tenant of hers. It just has to be one designated account that only the tenant's money goes into. Then when the money gets pulled out, the landlord can give a pro rata share of whatever interest it is to that tenant when they pay the deposit back. It's very important, incumbent upon the landlord to keep records of everything that goes into that account. All it is a ledger. This person put in $850, this person put in $850. For some reason, this person, we only had $800 from them. And keep a record of it. And then at the end of the day, the money goes back or it gets used for any damages that are used. Now, whose decision is it as to how that interest is handled? Because it could be handled in a number of ways. It could be paid to it could be a deduction from the rent at some point in time. It could be a cash back to the tenant. It could be held by the landlord until the tenant moves out, which might be 5 years down the road. Whose decision as to how it is handled? What's the fundamental question? Whose money is it? Who decides how it's handled? The tenant decides. Except in the situation where, at the very least, the landlord gives the money back annually to the tenant. So if it's the deal that landlord says, look, I just give it back I give the interest to people, the $1.33. I give back to the tenant at the end of each year, or the last month you can deduct. You give notice in advance saying, okay, you can deduct $2.13 from your rent at the end of this year, or I'll give you a check, whatever you want. That's fine. Yearly. If, however, and I actually had this situation. I had a case where it was a big company that owned a big complex. They had, I don't know how many units. And they mandated, this is what we're doing, that we'll give you your security deposit back and the interest on it when you ultimately move out later on. Can't do that because we had some tenants that complained. They shouldn't be able to keep our money for, we may live here for 10 years. So we shouldn't. And it's true, they couldn't do that. So they have to at least give it back yearly. So let's talk about the circumstance where it's 5 units or less. The rule still applies. It cannot be commingled. However, there's not a requirement that it be put in an interest-bearing account. Still, they can't put it in their own account. They can put it in their sock drawer as long as the rest of their money isn't in the sock drawer. They have to somehow keep it separate. And if it is an interest-bearing account, it does belong to the tenant. What happens security deposit-wise when the property is sold? The seller should transfer, the old landlord, should transfer all the security deposits over to the buyer. And landlords, if you're going to sell the building, use a lawyer to sell the building. And make sure the lawyer does, in the closing numbers, adjustments to transfer all the account over. Or even better yet, the landlord comes in with a separate check at the closing that just represents the security deposits and has a list of every tenant and how much is made up of that security deposit and hands it over to the... Because if you don't, sellers, landlords, you're still on the hook. And the tenant, you want to be, I presumably want to be done with the building by selling it. The only way you can do that is if you transfer over all the security deposits. If you don't, you're still on the hook for that. So make sure that that happens. Make sure you have documentation showing that it's transferred over, because when the tenant contacts you, you can say, I have documents that show I transferred that money over to the new landlord. Go talk to him or her about getting your security deposit back. When must the security deposit be returned? And that's, to many people's chagrin, no definitive time, unless you live in the city of Binghamton, or city of Ithaca. I'm from Binghamton. City of Ithaca is one of the rare, I think it's the only municipality in the 8-county area that the Binghamton Regional Office covers that actually has a rule. There's a local law in the city of Ithaca that says it must be returned within 30 days. For everybody else, it's within a reasonable period of time. What does that mean? And I say, I use it jokingly, tongue-in-cheek, say, reasonable is a term that lawyers get paid a lot of money to define. But I think as normal, reasonable people, we can come pretty close to figuring out what is reasonable. 30 days sounds to be pretty reasonable. 2 weeks sounds to be pretty reasonable. 45 days, we're starting to get really near the end of reasonable. And why is that? Because the landlord has to have time to investigate options related to potential damages and things like that. They have to have something fixed. They have to have a contractor come in and give them estimates, all that. And it takes a little bit of time. But that should be done expeditiously. It shouldn't be done to take forever to do that. So the law has said it must be returned within a reasonable period of time. So let's all be reasonable. I've gotten complaints from tenants throughout the years that I moved out 3 days ago and he still haven't gotten me my security deposit back. I say, what? Hold on. Give them a little time to get it worked out. But then, we get longer period. I've had where tenants have been several months that get their security deposit back. That really is too long. And again, in the city of Ithaca, it's a 30-day obligation that they put on the landlords. So that's kind of how the whole security deposit issue gets handled. Let's kind of morph over to the other side, where as an assistant attorney general doing the affirmative justice cases, I'm a consumer advocate, but I also recognize practically that there are not only tenants' rights, but tenants also have obligations as well. The tenants' rights, of course, they're able to live in a habitable residence without interference from the landlord, to live peaceably. And, remember when I talked about starting out, the tenant gets exclusive use and occupancy of that residence for the term of the lease, which means the landlord has no rights to go in and inspect. They gave up exclusive use and occupancy. The only right the landlord has to go in is in the case of an emergency to protect his or her interest in the property. I'll use the example I frequently use here because it's the rental housing is so much dominated by college students here. Let's assume for the moment that the college students go home on break at the holidays, and there's a tenant living downstairs and continue to reside there, and all of a sudden they look up and there's a water stain. And all of a sudden water starts dripping down. And they hear water running upstairs. And they call the landlord. The landlord would have the right on an emergency basis to go in to find out what the problem is, whether it's a leak or water was still running or something was plugged up or something, and get it taken care of and get out. That's what they have the right to do. I would encourage a landlord, if they were to do that, go in with a witness. Do only that. You're not entitled to inspect as far as, man, this tenant is a messy, sloppy person. There's junk, they storing stuff all over the place. If it is not a environmental, fire hazard kind of thing, you have no say. You can go in, you could do an emergency. Emergency doesn't mean replacing the countertops. Doesn't mean redoing the bathroom. If there's an emergency, you can do it. Now, the parties can agree as a part of the contract to alter that, but still the landlord can't unreasonably interfere with the occupancy of the tenant, making monthly inspections and things like that. It's getting on the verge of unreasonable. And there is a underlying provision in the law that says any unconscionable contractual provision is void, meaning it is illegal, unenforceable. So if there's a provision in the lease that says landlord reserves the right to go and inspect every morning at 8 a.m., I think you probably find a court to say that that's unconscionable, to have a provision where the use of the premises has been interfered with to the extent that it's unconscionable. So that there is that general fallback provision that's in there. I'll throw in an additional one that kind of I see frequently. And it goes along with tenants' obligations. The number one responsibility of tenants is pay the rent. Pay the rent on time. The landlord has obligations, financial obligations related to the property, may have a mortgage, has taxes, has insurance, has other expenses. They are entitled to receive their rent and to receive the rent on time. There is no excuse for the tenant to be able to say, things were a little tight this month. I have to go to work and I had to get my car fixed. I didn't have the money. Yeah, we feel for you. Yes, there's those emergency situations. The landlord is still entitled to get their rent and get their rent on time. And that's an obligation that needs to be paid and getting taken care of. There may be provisions in the lease, and this gets into the possibility of unconscionability. For late fees, it is legitimate for a landlord to put in late fees in the lease if it isn't paid on time. They have expenses that have to be paid, and so they're entitled to get it and entitled to get it when it's due. This said, it must be a reasonable late fee. $25 a day, in my mind, is unreasonable. Think about it. They're 10 days late, and it's another $250. I know that landlords want to give an incentive to pay the rent and pay it on time, but it can't be an unconscionable penalty to where it never ends and it racks up. When you think about it, if somebody I haven't done the calculation, but $25 a day on a rental of $850 is an astronomical interest rate. If you compute that every day over 30 days, it is huge. And then compute that over a year, that is huge. So now, if it's reasonable, if it's, I'll just grab a number. I'm not trying to say there's a definitive number or amount or anything, or if it's a certain percentage, or if it is, you know, a $25 late fee if it's not paid within like 10 days, and it doesn't accumulate at $25 a day and things like that, and you can, the best thing is if you can apportion it to costs. You know, because it costs me, my carrying charges on my mortgage are this much and I can't pay the mortgage. If you can relate it to something, you're getting much more reasonable. So the bottom line is we just have to be reasonable in associating with it. And I know that we do want the incentive to pay, but again, we need to be reasonable. So first and foremost, obligation, pay the rent, pay it on time. The next obligation is tenants must fulfill all their obligations under the terms of the lease. Whatever they're supposed to do under the lease, they got to do it. If they don't, we fall back to that breach thing, and that may give grounds for the landlord to terminate the lease. So fulfill all the obligations. Another fundamental, yes, question.
What happens when the lease contradicts certain rights of the tenants? Is the tenant still obligated to follow the lease if, say, for example, you gave the 30-day security deposit example in law in Ithaca, is if the landlord says you'll get your security deposit back in 50 days, is that something that because the tenant signed the lease?
Interesting question. The question is that what if the contract provides for something other than what the law provides for? For example, the local law in the city of Ithaca is that the security deposit has to be returned within 30 days. The contract provides that it's in the city of Ithaca property, and the contract provides that the security deposit will be returned in 50 days. It's unclear how that would happen. It sounds like it would be a breach of a violation of the local law that might subject the landlord to enforcement by the city itself, but it probably doesn't have any impact on the contractual party. It's not a breach of what their contract was. So the contract would govern the relationship between the tenant and the landlord, except, however, we've got this local law that come on top. I mean, going into that circumstance, I would say that the tenant would say to the landlord, you know, the local law here says it's 30 days. Let's cross that out and put in 30 days and see if that can get taken care of. Something along those lines. So the fundamental end of lease thing, and that's a good segue, is the obligation of the tenant is to return the property in the same condition it was received, reasonable wear and tear accepted. Meaning, reasonable wear and tear, the normal daily use of a residence, things wear out over a period of time. And when they wear out through the normal customary use, the landlord has to expect that the property will be returned to him or her as being used. So we sometimes will have the instance where the landlord keeps the security deposit to repaint the apartment, unless the tenant has caused damage. Their kids decide to use crayon throughout the apartment. Unless there's some type of damage associated with it, repainting is normal and customary. I mean, we have to do that. That's just, it's the cost of doing business. Those of us that own houses have to paint periodically and things like that. So just through normal wear and tear, that the place has to be repainted, the landlord cannot use a security deposit to do that. That's just normal. Carpets wear out. Things happen. Stoves eventually wear out. Appliances, those sorts of things. So if it's not through something that was damage causing, it is not a security deposit issue because it's reasonable wear and tear accepted. Again, that term comes in again, that reasonable thing. You know, how do we define that reasonable thing? And again, I think that in 99% of the cases, we can all agree what's reasonable. I've had circumstances, I litigated a case early in my attorney general days when the Binghamton University rented, before they built these beautiful dorms. Oh my gosh, the dorms now on college campuses are just gorgeous. There was a lot of people wanting housing on campus, and there was not campus housing available, so that Binghamton University rented an apartment complex, their own complex, for 10 years while they were contemplating what was going to go on campus. It was close to campus, and they returned the property at the end of 10 years. Now, we know how college kids can live, and we know that sometimes they tend to treat things a little bit differently than what other people would. And we had a long trial on, was the property returned to the landlord in the same condition as received, reasonable wear and tear accepted. And so we actually we battled over what the definition of reasonable wear and tear was over a whole apartment complex. On a much smaller version, each tenant would kind of have that, what's reasonable wear and tear. So it could come down to a fact issue, and I can't stress how important it would be for landlords and tenants to take pictures or video going in and going out. If there is damage going in, the countertop has burn mark on it, or the stove is maybe in a used condition going in, take pictures of it. So that at the end, when you try to get your security deposit back as tenants, or as landlords wanted to keep the security deposit, you can match, move in, vacate. Oh, this is not reasonable wear and tear. This is damage that's caused. I have to have this fixed, this replaced, whatever. I'm going to deduct that from the rent, and when the tenant comes to the landlord and says, hey, I want my security deposit back, and you say, well, I'm not giving it back to you because of all this damage, the tenant could go and sue the landlord for refund of the security deposit, and the landlord can go in and say, here's a picture moving in, here's a picture moving out. This is damaged, we charged back for this. Tenant, the same thing. This is what the place looked like when I moved in. This is what it looked like when I moved out. That damage that the landlord is saying that was on the countertop existed before I moved in. It was something that I inherited. I shouldn't be responsible for replacing this, that, the other thing. Pictures do speak 1,000 words when it comes down to this. So really, take pictures or video going in, take pictures or video going out. I know that Ithaca has a very active code enforcement office, and speak with a landlord first about these particular issues, but you can potentially contact code enforcement on other things related to the condition of the apartment. So let's segue on to everything was great. Everybody, rent was, well, let's not say that. Things are going good, and then it comes to a point in time where there's a problem. The typical problem is tenant doesn't pay the rent when it's due, and it's past the period of time to do that. What can be done? First, landlords, you may not undertake your own efforts to throw the person out, because there's this relationship that was created when you entered into the lease. And that is that exclusive use and occupancy, and it's binding, and there's only one person that can terminate that bond, and that's the court. The court will sever that bond, thereby allowing the landlord to get his or her property back, sever that exclusive use and occupancy, and to have the tenant get out. And that is an eviction proceeding. You must go through the process. You can't turn off utilities. You can't start throwing their things out the second-story window because they have not paid the rent. as difficult as it is to still have to, let's assume that the utilities are included in the rent and they haven't paid the rent. Well, I'm not paying the utilities because I haven't received the rent. You must continue doing that. As bad as that seems, you must continue doing it. You still have to fulfill the obligation until the court severs the relationship and could give you a judgment for the amount of utilities that are owed. You can't just go and turn things off, change locks on doors and things. You cannot do that. It's against the law. I would tell, if a landlord calls or a tenant calls us with that, call the police. Call police and call code enforcement. Cannot do that. You've got to go through the steps. And there are very definitive, finite steps that have to take place. So I'll go through those because if you miss, if you don't dot all the I's and cross all the T's, you got to start over again. So here's the process, and this is to the advantage of landlords and tenants. You must do an eviction proceeding. We are talking about the most common one, which is an eviction for failure to pay rent. The eviction for failure to pay rent requires certain steps. The first thing that a landlord must do is serve the tenant with what I refer to as the first 72-hour notice. The first 3-day notice. And that is after the rent is due, they must serve a notice on the tenant saying the rent, you owe rent for, let's say, the month of May. You owe rent in the amount of X number of dollars for the period of, and we'll say May 1. $850. You must pay the rent within 72 hours or vacate the premises. That's what you had to do. You got to give them notice, pay or get out. Pay or get out notice. 72-hour notice. You can get them at a legal stationery store if they have them anymore, or probably online or whatever. But you have to give them the notice. It gets served on the tenant. The tenant, you must pay the rent within 72 hours or you are subject to being thrown out. And my experience has been that 72 hours is one of the fastest 72-hour periods of time you'd ever think about. It goes by quick. You got to make sure you do it. Because then what happens is the landlord, that is a precondition to starting an eviction proceeding. So what the landlord then must do is actually undertake the eviction proceeding. So let's assume for the moment that within the 3 business days, the rent is paid. It's over. Can't do an eviction. You got the rent and you move on. If after the 3 days the rent has not been paid, what the tenant must do is serve court papers on the landlord must serve court papers on the tenant. And that is 2 papers. It's called a notice of petition and petition. The petition outlines why the landlord is entitled to get the property back. They're entered into an agreement for a year that the rent is $850 a month. Rent is due and owing from May 1st, and there's a paragraph in it that says, on such and such a date, more than 72 hours ago, I had delivered to the tenant a 72-hour notice that had either he paid or he gets out. He has neither paid nor gotten out. I want my property back. And by the way, I want a judgment for the amount of rent that is owed. The notice of petition, under our constitutional framework in the United States, there's a thing called due process. You've heard about it all the time. Due process is simply 2 things: notice and an opportunity to be heard. That's what we require, notice and opportunity to be heard. So this is the notice. And the opportunity to be heard is the court date that's listed on the notice. So the notice is, I'm bringing a proceeding on such and such a date in court, 10 a.m., whenever they do the evictions. You have to check whatever municipality you're in when they do the municipality does their eviction proceedings. Here's a real important thing, and this is an I dotting or a T crossing. that notice of petition and petition must be served on the tenant between 5 days and 12 days before the hearing. So what you do is you figure out what date the hearing is. You count back 5 days. It's 7 days in between. So you got a 7-day window. You count back 5 days, and then you count back 12 days. In that window of time is when you have to have that served. If you serve it 15 days before the court date, out, start over again. That's because they don't want giving too much notice. People forget. If it's 5 days before, it's not soon, it's too close to the return date, doesn't give enough time. Out, got to start over again. Between 5 and 12 days before the date that you're in court, you must serve the notice of petition and petition on the tenant. You go to court on the day designated. The tenant walks in, and that really the only thing the court hears is rent was due, it hasn't been paid. If the tenant comes in and says, Judge, I just need another day. I had to have my car fixed, I had a medical bill, but I just need another day. Technically, there's no discretion. Technically, it's rent's due, not paid, eviction. Some judges may say, hey, landlord, how about if I sign the warrant and date it for 2 days from now? Gives the chance for the tenant. They say they're going to have it, but you know, I'm going to date it 2 days from now. It depends on the judges and how they handle it. Straight law is the rent isn't paid, the judge signs it's called a warrant. It's not like an arrest warrant. It's a warrant. It's to sever the relationship and give the property back to the landlord. If the tenant comes in and pays the rent, it's over because the rent's been paid. But we're going on the scenario that didn't happen. The judge signs a thing called a warrant, and that just says the property is hereby turned back over to the landlord. Then what the landlord has to do is take it to an enforcement officer. Back in the day when I was practicing law privately 30 years ago, municipalities used to have like constables and things, and the enforcement officer for the town could actually go out and serve it. There aren't too many of those anymore. A lot of times it's the civil division of the sheriff's department. That's where a lot of people, I don't know if the city police does evictions, but you got to check around. And I know that the city, you check with the civil division of the Tompkins County Sheriff's Office, and they'll give you some instructions on what to do. And you have to give them the warrant. And it depends on the law enforcement agency, but sometimes you have to give them the notice of warrant as well. And what that is the notice of warrant is the second 72-hour notice. The law enforcement goes to the tenant with the warrant and with the notice of the warrant that says, here's the warrant, I'm going to be back in 3 days. I'm going to be back in 72 hours. You're either going to be out or you're going to be thrown out. I've never had, in my 30-some years of practicing law, I've never had that actually happen. I have had the situation when I was doing an eviction for somebody where the constable, this is back in the days when there was a constable, went to the door because the tenant hadn't left yet, and knocked on the door, and the tenant opened the door, and he said, I know, I'm going. And they walked out the door, and that was the closest it came. Question? They pay no, it's too late. The warrant has been, if they paid at the time that the sheriff, all the sheriff is the law enforcement officer to keep the peace. The court has already broken it. It's too late. By then, the tenant has the landlord has a judgment against the tenant, and it can collect the rent. They have to go. It's 72 hours. You got to go. What if they paid on the fourth day after the first 72-hour notice? The landlord has to take it. And they're proceeding, if they haven't started the proceeding yet. If they have started the proceeding, that's a gray area, because what the law pretty much says is if the landlord accepts the rent after the proceeding has started, it's over. So the issue comes to whether they say, I'm not accepting the rent at this time, the proceeding's already started, we'll go to court and see what the judge has to say. Okay? So the tenant must move out within that period of time. For those of you that are landlords and actually have to get to that point where they have to move out, the sheriff does not bring their posse with them to move people out. They just are there to protect the peace. So the landlord would, if that were to get theoretically to that circumstance where they would have to move the stuff out, the landlord would end up having to physically actually do the moving. How does the landlord have to act? The landlord has to act, you'll be really surprised at this, the landlord has to act reasonably. And reasonably means if the landlord, let's say there's no new tenant going in right away, the landlord could change the locks at that point. The stuff is still in there. The landlord can't act unreasonably. When I say unreasonably, is throwing the stuff out the second-story window. The landlord, if the landlord has a, potentially has a garage out back that's not being used or something, and the stuff can be put in there, hey, maybe that's reasonable. If the landlord is not obligated to safe keep. If there's no other options, the landlord could potentially put the stuff out on the curb. I mean, just because there's no other option. So I guess the best explanation and advice is act reasonable. What would a reasonable person do under these particular circumstances? And if you act that way, usually there's not going to be a problem. If someone were to have a problem related to this, somebody didn't get a security deposit back, thought they should have their security deposit back or something, our office, we get so many of these complaints, our office actually has a rent security deposit complaint form. The tenant can fill out the complaint form, send it to us, we send it to the landlord and say, we've only heard one side of the story, we try to mediate the complaint to resolve it. I will tell you, there are lots of times that the tenant complains and we send it to the landlord and then we get a response from the landlord with pictures of what the place looked like when the tenant moved out, and then we can say, I get it. I can see why it wasn't refunded. But landlords, again, document everything. It's so much easier because if you're going to face a small claims case or something, have your proof there. You can say, here's pictures of the bathroom, here's pictures of the living room, this is the kind of place that they left. It cost me X number of dollars to fix it up or whatever. Just have all your ducks in a row so that you can protect yourself when the time comes. Oh, also, one last point, and I know we've probably been going kind of too long, is don't expect tenants. Don't expect. Just because you paid 1 month's rent, that's not the limit of your exposure. It's not. If your deposit is $850, the 1 month's rent, and you cause $2,000 worth of damage, you can be subject to being sued by the landlord for the difference. It's not limited to just what the security deposit is. So those of you that may be watching, the college students out there that say, end of the year, big bash time, we're going to be moving out of here. We're not going to be here. Let's have a big party and people go wild and they cause damage and things. You can still be on the hook for all the damage that's caused. Don't think, I'm not going to get my $850 back anyway. I'm going to make it worth it. Your exposure is the entire amount of damage. And there was an experience that some students in the Binghamton area did that. And when they moved out, there were $35,000 in damage. And the parents co-signed on the lease. They got stuck having to go do the repairs themselves and pay any extra damage that might have been caused because their kids wanted to have a good old time. So keep that in mind. Treat the property as if it was your own and you owned it, because that is really how it's looked at under the law, and you'd be responsible for those damages. If anyone has a question related to landlord-tenant, I'd be glad to answer those questions. We have a question in the back.
If you're somewhere with a 1-year lease that you've signed
a 1-year lease.
And the manager of the property
2 months after you sign the lease, a manager shows up.
With some
New stipulations, conditions, provisions.
What are your,
You are not bound by any new, your lease is the terms that you signed for the length of time that you signed it. And that raises, see, this is why I'm glad people ask questions. That raises another thing. I'll get to in a second. So they can't, nobody can, the tenant can't change the terms, and the landlord can't change the terms during that agreement. Both parties are bound by those terms. Once the lease expires, it, by operation of law, converts to a month-to-month lease. Okay? A month-to-month lease is, in essence, a new lease every month. So that means either party can change the terms of the lease, but it has to be noticed to the other party 30 days in advance. It's better off as an example. Lease is expired, you're on a month-to-month. Or you're just on a month-to-month from day one. Even though you're on a month-to-month, this is a segue. Even though you're on a month-to-month lease from day one, still get it in writing. You can write on the lease, month-to-month lease, still get everything in writing. So if it goes by operation of law, it's a month-to-month lease at the expiration of the term. Either party can get out of that agreement by giving notice to the other side 30 days in advance before the beginning of a term, which means before the first of the next month. Give notice, either landlord or tenant, give notice to the other party, you're going to be out at the end of at the end of that following month. Or the rent's going up effective using months. May 1st, the lease expires on April 30th. So prior to May 1st, it's going to go to a month-to-month tenant, and on April 29th, the landlord gives notice to the tenant, your rent is going up effective June 1st. It's more than 30 days in advance before the beginning of a term. And then the tenant is stuck. The tenant's got to live by those terms. Or the tenant would give notice on April 29th, I'm going to be out on May 31st. And the landlord can't keep the person any longer. That is not a great example because under those circumstances, we have to assume that it's been an ongoing month-to-month tenancy. If a lease is a one-year lease and it ends on April 30th, you got to get out at the end of April 30th. That's just because that's what you agreed to. Everybody agreed that that was the way it was going to be. But if you're on a month-to-month tenant, it's 30. Either party can change the terms on 30 days' notice before the beginning of a term. Next question.
how long does a landlord have to fix something?
How long does a landlord have to fix something? A reasonable period of time. Okay, so I know that's so frustrating, a reasonable period of time. But I tell you, it is a great term. It's a great term. And why is that? I'll give you a scenario. What if, now that we finally have spring, finally has broken, what if the furnace goes now? How long does the landlord have to fix it? Maybe by November, October, whatever. What if your furnace goes on January 2nd? How much time does the landlord have? A lot less than when it would if it goes in July. Well, there's no set time, whatever the reasonable period of time. What I encourage people to do is, let's use that scenario. It's an emergency situation. It's January, the heat goes. The landlord has the obligation to expeditiously get that fixed or look into it. Yeah, it takes a little while to get a contractor to look at it. If the landlord immediately comes out and says, ooh, this is bad, we got to get somebody in here, and can get somebody in, it's the same scenario for the tenant as if the tenant owned the house. How long would the tenant be able to go if it was their own house? A reasonable period of time. If you get a contractor, 2 months? No, absolutely not. the landlord can't lollygag in getting it done. The landlord has to treat it as if it was his or her own house. How long, if you were living here, how long would it take you to get this furnace fixed? That's the amount of time it would take. So, next question.
Oh, just if the porch that they use to exit and enter their house.
The porch for ingress and egress. The step is bad.
Or there's a missing board.
Or missing boards. And they have children. I don't think it matters really if you have children. I think it's broken. It's a safety issue. Whether you're young or old, it's a safety issue. They have a reasonable time within which to fix it. They can't let it sit there. They have to get it fixed so that if that's the main entrance area and it's a potential under the circumstances, you got to do it expeditiously if it's going to cause damage. If you don't, we fall back to the scenario we talked about before. The tenant gets a contractor to come in and fix it. Or the tenant takes reasonable steps. They get some boards and fix it themselves and give the bill to the landlord and say, hey, I had to have it. It doesn't look great. Come in and get your people to come and do it. It's functional now. It costs me $50 to do this. Do you want to give me the $50 or do you want me to just deduct it from the rent? You have the conversation and try and get it resolved. Any other questions as we're wrapping up? Yes, one more. Smoking and non-smoking.
There's a new issue here.
Yeah?
Specifically in
Tompkins County.
Smoking is no longer allowed in public housing under...
Smoking is no longer allowed in public housing. Federal law requires it, okay.
Ithaca Housing Authority is implementing non-smoking...
Non-smoking implemented by a not-for-profit in the area. Starting May 1st, okay.
So it looks like the choices for Section 8 housing to be available for smokers is in a couple of older apartment buildings, which
so put smokers in a bind for
puts the non-smokers who already live in that housing in a bind because if they have
okay.
Now subjected to smokers.
Gotcha. Gotcha. I got it. Here's the issue. There's certain requirements that you can't have smoking in certain federally subsidized housing buildings and things, not-for-profits that are getting housing funds and for low income. So they have to get rid of all the smokers out of their building because that's federal law. They're not going to allow for it. So then the smokers move into other maybe private housing that the landlord will accept Section 8 and things like that. But then those smokers are smoking and the non-smokers in those particular buildings are put into a bind because smokers have moved in. There's a whole host of things. I don't know if there's local laws that also deal with smoking or non-smoking. If whoever has the housing allows smoking to occur, and it puts other people in a health situation, there is nothing in the law that makes that apartment now uninhabitable. So what, in essence, would have to happen is that people would have to move. Now, you would think that if there's enough non-smokers around, the landlord is going to lose. There's going to be a couple of things. One is the landlord is going to lose the non-smokers. I have had experience knowing that smoking in a building can cause significant damage to the building, the walls and things. I've had dealt with landlords that had situations that they had to use special paints and primers and things because with the smoke, if it's a heavy smoker and it adheres to the walls, you can't paint them and things because the paint doesn't adhere and that sort of thing. So they're losing the value of their property as well. But there's nothing that I'm aware of that makes it that the non-smokers can do anything to force the landlord to make it quote-unquote non-smoking, so that they would have to move, potentially.
Which you understand is really difficult.
It is.
Tompkins.
It is difficult in Tompkins County. It's difficult in a lot of counties.
Yeah.
My experience has also been that more landlords, because of the value diminishment of their properties and things, are more apt, not exclusive, but more apt to have a non-smoking policy rather than a smoking policy, simply because it's not in their economic interest lots of times to do it that way. But in this situation, there is no answer for those circumstances.
But even if there's no clear legal motivation, can you recommend some sort of mediation group?
Can I recommend some sort of mediation group between the non-smoking tenants and the landlord to try and get it so that it's not smoking?
Well, we could advocate to move the tenants and maybe the landlord
Move the smoking tenants?
to a different part of the building.
Again, that
Like
about moving the non-smoking tenants to a different part of the building so that the smoking doesn't interfere with them. My experience has been that those who are really allergic to the smoke and things like that, moving into another section of the building sometimes is really also not a good option because they're so severely allergic to it. But I don't know the not-for-profit mediation entities in Ithaca. I would encourage you to find local contacts. Maybe Cornell Cooperative Extension would have somebody that you could talk to that could direct you to those agencies that could do the mediation of just any problem with the landlord, frankly. Thank you all for attending. It was great to have you. It's always great to have people here. We've already, as I mentioned at the outset, the questions that are asked make me think about things I forgot to speak about. So it's great to have people come here. And we are here on the second Thursday of every month at 11 a.m. to where we do the show. And then I'm usually here till 1 in the afternoon if people come in. If they not, I bug out. Come join us. We hope to see you here at Cornell Cooperative Extension on Willow Avenue for our Consumer Issues program. Until next time, I hope you all have a good day. Thank you.